Good afternoon, everybody. It is 1 o'clock on Friday, December 8th. This is our third in a series of three different training seminars that we're holding for towing carriers. Our first one was back on October 30th, and the subject matter was rules and legislation. Our second one was held on November 17th, with the topic being covered administrative items such as applying for a permit, correctly filing your insurance, being able to navigate the PUC's website to conduct different business with the commission, and other things of that sort. And today is our final in this series of towing training seminars, and one most of you are probably most interested in, which is complaints, investigations, and enforcement. So we'll be covering a range of different topics today. Let me go ahead and get our presentation up and running, and then we will get started. All right, so everybody should be seeing the slideshow now. We do have a presentation, just like with our other two training seminars. And again, our primary concern is to get through these presentations just so we have a lot of time to cover everything. Our time window for today's seminar is 1 to 3, just like the other two. The other two ended up wrapping up early. This one I expect probably will not, just because there's a lot of different things we need to cover today. And I'm sure a lot of you will have questions. Speaking of which, if you want to engage as we're going through the presentation, I have no objections to that as long as we don't get too off topic, just because, again, we do want to get through the entire presentation. But you can control the ability to raise your hand through the Zoom program. So you can either just use the buttons if you're on a computer, or maybe even your phone. You can do that. If you've dialed in to participate today, you can, I think, raise your hand using the *9 function. So you hit *9 and that raises your hand, *9 again to lower it. And you can also mute and unmute if you've dialed in using *6. Otherwise, if you're participating on Zoom on your phone or on a computer, I think you can sorry, I have a technical difficulty here. But anyway, yeah, so you can use the Zoom program features such as raising your hand or muting and unmuting. I'm assuming everybody can hear me okay. Can someone just type something in the chat real quick and let me know if you can hear me okay? Okay, thank you, Rochelle. I appreciate that. Okay, and you too, Rhonda. Appreciate it. Okay, thank you. I'm wondering if I got a message that maybe the stream on our YouTube channel is not working, but maybe it's something else. All right, well, we'll go ahead and move ahead. I believe we're recording this, so even if the stream's not working, and I've indicated this in our previous trainings where we're going to be posting all of these recorded training seminars up on our website. We're going to see a copy of our website here in a minute, and I'll show you kind of probably where it'll end up once we get it posted. I think we were waiting for all three to be done before we posted any of them, but that should be happening here in the next week or so. All right, moving along, let's go ahead and jump into the presentation. So again, what we're covering today is towing, complaints, investigations, and enforcement. So the first thing we're going to talk about, and we've talked about this at the beginning of all of our training seminars, which is our website. It's really a good place to go. A lot of good information and resources here that you can use to conduct various business with the commission, or just learn a few things. There's definitely a lot of good stuff here. Here is the main PUC webpage. So this is for the entire division. So it covers all the different utilities, energy, telecom, gas pipeline. And you can see there circled on this is transportation. So that's where you'll go to get to the transportation specific webpage. But there's other good things on this particular part of the website as well. If you scroll down a little bit from the image that's shown here, you can see important notices, the ability to watch streamed events such as this one, or other hearings, weekly commissioner meetings. You can find recordings and also watch things live there. Also at the very bottom, there's a calendar, so you can see what kind of things are coming up in regards to commission business. There's usually links and stuff to participate in some of those matters if they're more public. So a lot of good stuff you can find just on this main PUC page. Moving on to our transportation specific page. So where we are now, this is kind of what it looks like. We have links to all the different primary carrier types that we regulate. So you can get to those carrier specific websites directly right from here. So you can click on common carriers, for example, or towing carriers, for example, and it'll take you to the towing and common carrier websites respectively. So feel free to use that. It's just kind of a quick jump to kind of go deeper in or get more specific in what you're looking for in transportation regulation. If you scroll down a little bit from what I'm showing right now, you'll see links to different things. There's some notices for kind of more important things that have happened recently that you want to be aware of. Also, that's probably where we'll post these trainings here in the coming week or so to get those up there. So it'll be available here. Oh, no, sorry, not on this transportation page. We're going to put it on the towing page. That's what I'm going to show you next. But other good things on this main transportation page is if you scroll down a little bit, there's some blue boxes. One of them has the rules for transportation. There's some common forms available here. There's a link for consumers where they could file a complaint if it's a consumer looking at this webpage, and some other things as well. So some good stuff you can find here. Moving on to specifically the towing webpage, and sorry, this is where we're going to post the trainings once we have all the recordings ready. We'll put them somewhere on here, probably just above the blue boxes, kind of on that left-hand side. There's already a link there, I believe, for the most recent PRPC training that we did as part of that organization. It's similar to the slideshow I'm showing here today. There's some differences, but that's linked there as well. But yeah, the recordings will probably be linked there next to those buttons on the right. But a lot of good stuff on here as well. You have our statutory authority. The kind of image and text above is a consumer advisement and some other notices. You also have the ability to purchase stamps here, apply for your permit, or renew for your permit. One of the more important things here is the tow rates as well. So you always want to make sure you're using the most current version of tow rates to apply your rates and charges. So there's that button there kind of halfway down the page on the right where you can click on that, and that takes you to a Google Drive folder, which has both the current rates and then previous time windows of rates before that, because the rates do change from time to time. So you can always look back and see kind of what the rates were before, but for immediate purposes, you'll probably be looking at what the rates are now, and it says current rates. So those are the ones you always want to make sure that you use. In addition, the monthly fuel surcharge, that does get updated monthly at the beginning of every month. So make sure you visit at least once a month to check in and make sure that you're charging correct rates for mileage with the addition of the fuel surcharge. And also a link to the towing task force. So if you're interested in what they're doing, there's recordings of their meetings and minutes and a copy of the report they submitted last year. It's all there. So, and then scrolling down a little bit further into those blue boxes, you have all your common forms. So those are the forms you want to make sure you're aware of and that you're using for different business that may need those forms. Also business forms. So if you want to update your name or your contact information, there's forms for that as well. And then again, some additional consumer references as well. All right, so we'll just do a quick skim through the rules real quick before we get into the enforcement and complaint and investigations process. So for rules, obviously we have our general provisions under the 6,000 rule series, which is a lot of just the generic requirements for most of the carriers that we regulate. And so it includes things such as making sure that your name, matches your insurance, and that your insurance is filed properly in what amounts. Also, making sure you're advertising correctly, things of that nature. So it's some just general requirements that apply kind of across the board to most of the carriers that we regulate. So if you haven't yet, I would encourage you to go in there and read through that set of rules, just so you're aware of them. And as always, if you have questions, you can always reach out to PUC. We'll explain what we can. Moving on to the safety rules, that's our 6100 series. So that's safety rules that apply to, again, most of our different types of carriers, not all of them, but most of them. What you definitely want to pay attention to here for safety rules for a towing carrier is under 6100B as in boy. So it's right there in the middle of this, what I'm showing you here. So it makes references to 49 CFR. Those are the federal regulations. So essentially, if you are using a vehicle that is going to be considered to be a commercial motor vehicle pursuant to those standards, based on either DVWR, the weight rating, or, passenger count isn't really going to apply to towing carriers. But if that's the case, then, you just got to be aware of those 49 CFR standards because they are going to apply. So just be aware of that. Moving on to the towing specific rules, and that's what we'll be talking about most today, is the 6500 series rules. So basically 665 and then whatever the other numbers are going to be tow rules. So this is the section of the rules you want to definitely pay the most attention to. There's definitions for what different terms mean within the rules. There's also some rules on how to apply for your permit, what the background checks are like, equipment that you need to have, also things on authorization, tow invoices, rates and charges, release procedures, notifications, signage. All of that is in the 6500 series rules. We obviously are still, and I'm sure most of you are aware, we are in the middle of a towing NOPA right now. That's a notice of proposed rulemaking. So we are right in the thick of some proposed rule changes right now. We did have a recommended decision for those rules issued back in late October. And I think the commission's likely going to be discussing that very soon. So, but nothing's official yet. It's the rulemaking process. There's a lot that goes into it. We covered that quite a bit in the first of these training seminars. So until you get word that the rules are actually effective, just be aware of that. All right. Jumping into some other requirements you want to be aware of, which is your statutory requirements. So under 4010.1, those are the PUC statutes. From 4010.1, 101 through 118 is the general PUC statutes. Not all of them will apply to you, but some of them will. So 4010.1, 107, for example, is the insurance requirement. So that's essentially what gives the commission the ability to impose certain insurance requirements on all carriers, including towing carriers. Now, of course, this is further refined and reflected in Rule 6008, which you need to be aware of as well. But this is where it derives from in some of these statutes. Going on down, 4010.1, 401 through 410 is the towing statutes. I'm sure everybody's aware, House Bill 2213-14 last year did add some additional statutes to that section. I think prior to that, it didn't go any further than like 403 or 404. But now we have additional statutes that have gone in there. Most notably 405, which has made a lot of changes to private property impound, especially residential private property impounds. Moving on to Title 42 requirements. So those are the Department of Revenue statutes that you need to be aware of. Probably the most notable and the ones we talk about the most is 42.4, 1804, and 2103, which are the statutory. They're essentially the kickoff to abandoned motor vehicles in regards to statutory notification and subsequent stages for towing carriers to be able to essentially sell vehicles to recoup their fees if their vehicles have indeed been abandoned. So you always want to make sure. We have some subtle references to these Title 42 statutes in our rules, but you also want to be aware of what the statutes actually require as well, because we don't suss it out as much in our rules because they're not our statutes. Moving on to Title 49 CFR, which I just mentioned a moment ago. Those are our federal regulations. So most towing carriers that we deal with are going to be registered through USDOT just based on the size and weight of their vehicles. So there's that. FMCSA as well. Just make sure you are understand and are aware of those criteria. We can help with that a little bit. All of our investigators here are level 1 certified and trained with State Patrol that deals with these types of regulations and accompanying violations and enforcement on that. So just be aware of that. And then moving on to local requirements, there are some things that you just want to be conscious of, especially depending on where you're operating. Sometimes local areas or municipalities have their own standards. And again, as long as they're not infringing on the federal and state requirements, that's okay. So just be aware of those. I usually encourage all our carriers, not just towing carriers, to reach out to your local jurisdictions where you're operating and just check in with them. See if there's anything you're missing, or just to make sure you're doing everything appropriately. Again, there's not always going to be anything, but sometimes there are. So you just want to be aware of those. Something going on. All right, so let's go ahead and move into kind of the substance of our presentation today. So first off, I want to talk a little bit about our complaint process. So kind of just to give you an outline of how it works progression-wise through that process. The vast majority of our complaints are going to start with a different team outside of transportation at the PUC, which I'm sure some of you are familiar with. It's Consumer Affairs. So Consumer Affairs, they receive all the initial complaints that get filed with our office, not just for transportation, but for all the different sections within the PUC. So if somebody wants to call and complain about their electric bill, for example, they get those calls as well. So we work really closely with them and have a good working relationship. We meet periodically to kind of talk about different trends and complaints and what actions are appropriate based on different circumstances. So we're constantly in contact with them here in transportation, just to make sure we're all on the same page on how things should work. So just to kind of walk you through how the process works, starting with the filing of a complaint. So that can come in, and it generally comes from consumers, but it can come from really anybody who wants to file a complaint. Other carriers file complaints sometimes, or maybe law enforcement does, or other government officials, or consumer advocacy groups. I mean, really anybody can file a complaint. Usually we request that the person most close to the situation that's being complained about is the one who files, just because that makes it a little easier to navigate, but really anybody can file at any time. These usually come in either online or over the phone. So people can find links on our website to file those complaints online, or they just call into our Consumer Affairs hotline and speak to somebody and relay the information that way. People occasionally also do it in person. They may schedule an appointment and come into our office to just have a chat with somebody. And that's something that's accommodated for as well. Moving on to the next stage, once the complaint's been filed, then there's an initial review of the allegations. Again, Consumer Affairs is the group that does that on the front end. So they'll just kind of look at the information, see what's there. They do some initial vetting of the information. They're looking at issues such as, is this jurisdictional to us, and some other things like that. They also will have discussions with the complainant. So that's the person who's filing the complaint. We refer to them as the complainant. And then the respondents, which is the person being complained against. So in a towing complaint, the complainant may be somebody who got their vehicle towed, and the respondent is the towing carrier that towed the vehicle. So that's how we refer to them. So when you hear those terms, that's what it means. So yeah, as part of that process, the Consumer Affairs group, they will reach out to both complainants and respondents to kind of discuss what the allegations are and kind of just walk through exactly what is alleged to have happened. Then it moves on to, as part of that, requesting additional information or documentation, which could come from one or both parties. So, if the complainant is alleging a particular thing happened, if they have any information on that, maybe they have some pictures, maybe they have a copy of a tow invoice that they got that they don't agree with, whatever the case may be, Consumer Affairs may ask for that to be provided. Similar with the respondents, in a lot of cases, once a complaint is filed, the respondents are notified and given a short time period to essentially provide any documentation that they have associated with the situation that could assist with navigating what happened. So for towing carriers, it usually includes, if we're talking about a specific tow action, It typically includes a copy of tow invoice, any accompanying authorization, copies of bills if that's done separately, copies of payments, copies of statutory notification, and other paperwork related to the tow that happened. Those are the types of things that happen. I would also just stress, when those requests are made by Consumer Affairs, please respond timely. They typically give you a pretty decent amount of time to respond, but please respond within that time window, because that just keeps the whole process moving and doesn't bog the whole thing down. That just really helps us out a lot. So when you get those emails or those calls from Consumer Affairs, please respond in a timely manner. And also respond in a way that accommodates for everything that's being asked for, because Consumer Affairs is very specific in what they're looking for you to provide. So please provide everything that they're asking for, because again, otherwise it just bogs the whole system down, and it's not helpful for anybody that's involved. So yeah, please just respond timely and completely in situations. Moving on to the determination. So once Consumer Affairs has everything that they think they need to make a call on these cases, then, and again, it's always based on the evidence. So it's based on what people are telling us, based on documentation that's been provided from both sides in a lot of cases. And basically, after having reviewed all that, then a determination is made. And really, one of two things can happen. Either the Consumer Affairs group refers the complaint, which means they're essentially reassigning that complaint with all the materials that have been obtained up to that point to the Transportation Investigations team. Again, we're talking specifically about towing complaints here and other transportation-related complaints. It gets referred to the investigations team and becomes a full investigation. The other option is to dismiss the complaint at that point, and that could be based on a jurisdictional concern. Maybe what the complainant is alleging isn't within our purview. Maybe we have a statutory restriction from looking into what they want us to look into. Or maybe there's just not enough evidence to prove one thing or another. Or maybe a complainant alleged something, and then the respondent provided paperwork that negates the allegation. That's possible too. So when these situations come up, Consumer Affairs will typically dismiss the case, and that's essentially the end of the process at that point. Okay. Oh, one other thing I should mention. So this is the informal complaint process. We do also have what you call formal complaints, which is typically essentially a party versus party proceeding, where a complainant essentially is directly filing against a respondent, both of which are party to the complaint, and that typically involves being assigned to an administrative law judge and a hearing, and some other things like that. So that is another process that is available through the PUC. Moving on to the investigations process. So again, having considered what we just talked about with the Consumer Affairs portion, once it's been referred over to investigations, then there's some additional steps that are involved. So first thing is an investigator is assigned. So a specific individual investigator, or maybe a pair of investigators, depending on the situation, are assigned to a particular investigation once it's been referred, and then they are essentially responsible for it through the end of the process. So the first step typically that the investigator will take is they'll review all the information and documentation that's part of the case file. So again, everything that was procured and everything that was kind of navigated through the Consumer Affairs process all gets referred over. And that's usually the first step the investigator takes, is to just look at everything that we already have. So kind of what people have already told us, what documentation we already have, all that's forwarded over to investigation. So they'll review all that information and, just kind of see where they're standing on what they have. And in some cases, everything that you need is already there. You have all the statements you need, you have all the information and documentation you need, and you're ready to make a decision. That is possible. So, but in most cases, it's not that simple, and it usually will take things like additional interview. The investigator wants to reach out to some of the people, and maybe Consumer Affairs already talked to them, but maybe there's some additional questions that come up during their review. So additional interviews might be possible, complainant, respondent, other witnesses. Additional records might be necessary. So maybe Consumer Affairs got some of it, but there's one or two extra things that's needed. So they may reach out to both the complainant or the respondent or both to get that additional records or documentation that they're looking for. or maybe some field work. Maybe they need to go out into the field and inspect a property, or do a few other things. So there's a lot that goes into their additional side of the process here. After kind of going through all that and reviewing all the evidence, they make a determination, just like Consumer Affairs did, on any violations that may need to be cited. So again, that'll be based on the evidence. It'll be based on, in a lot of cases, paperwork, but also it could be based on interviews, could be based on admissions that have been made by the involved carrier, other things like that. And at that point, they've made a determination that there's sufficient evidence to support that the violations occurred. So really at that point, there could be pre-enforcement that they do. So that's things such, especially in the towing industry, we see that quite a bit, which is they could reach out and ask for you to refund a particular tow. Or some of you have probably experienced that. Or if you still have possession of the vehicle and it's the same situation, they may reach out and ask you to release that vehicle at no charge. That's also possible. And again, that's when they're doing that, they'll alert you, of course, usually in writing, and are free to now walk through the situation and all of that, if that makes you feel more comfortable. But really, that's an avenue that's available specifically through our Rule 6511G, which states, if any violations of either statute or rule are committed, then you can't retain any fees associated with that tow. So yeah, that's again, a lot of you have probably experienced that at least once in the past. So that's something that can happen, between when the determination on violations is made and when actual enforcement action is taking place. So moving on to the last part there on enforcement. So there's several enforcement mechanisms that the PUC can take. The two most regular that we do are violation warning letters, which is essentially like basically just outlining all the violations that were observed based on the evidence, based on the conduct that occurred, based on everything that the investigator has seen. And again, we list out the specific rules, and in some cases provide some additional context on how we came to that determination that violation had occurred, and all of that. Once we've served that violation warning letter on you, then that's essentially the conclusion of the case. There's not much action taken after that. On the other hand, kind of a step up from a violation warning letter is what we call CPANS, stands for Civil Penalty Assessment Notice. And what that is it's essentially a fine, is what it is. But yeah, it kind of works in the same way as a violation warning letter in that it lists out all the different violations that are being cited, and indicates, some additional context. Maybe if it's pertaining to a particular tow invoice, it'll cite which tow invoice it was, so you have that context, and some other things as well. So we'll talk a little bit more about the CPAN process in the next slide, but yeah, that's another pretty standard enforcement action that we take against carriers, including towing carriers. In the more severe cases, we do have the ability to submit and recommend criminal charges for individuals based on whatever the situation is. With towing carriers, especially when we're talking about authorization, obviously if someone just drives into a private property that they have no relationship with and starts towing vehicles from there, that's probably closer to auto theft than just an unauthorized tow. But again, we navigate those situations on a case-by-case basis, but we do try to maintain good relationships with different district attorneys' offices all over the state, and refer those types of charges when necessary. In addition to that, we also have things that tie to your permit. So we have Rule 6011, for example, where if we're seeing certain issues, we can potentially even go after a carrier's permit. And again, this is not specific to towing carriers; this is all the carriers that we regulate. We tend to reserve that for the more extreme situations, but that is something we have the ability to do. I suppose you could also look at the PUC's ability to run background checks on towing carrier principals and deny their permits based on that. Could, in a certain light, be considered enforcement. It's a little more administrative than that, but it does. Our enforcement staff are the ones who do that. And so, again, as I'm sure you're all aware, when you file either as a new towing carrier or you're renewing your tow carrier permit application, we do run that background check every time. And so, again, anybody associated with that application, we're going to run their background. And there's the disqualifiers based on felony convictions. Any felony conviction within the previous 5 years is a disqualifier. And then as part of HB 2213-14 last year, we have the additional ability to deny based on good cause, which is similar to what the 6011 rule I just mentioned does as well. So anyway, those are done more at the permit level than as associated with a complaint or an investigation, but it all kind of rolls into, just holding our permit holders up to a particular standard. So moving on to the civil penalty discussion and kind of outlining that process so everybody's aware of kind of how it works if when you should receive a CPAN someday, or maybe you've already received one and you kind of understand these steps already, but we'll go ahead and walk through it. So again, CPAN stands for Civil Penalty Assessment Notice. Again, it's like a fine. So the first step is to serve the CPAN. So we have to serve the CPAN upon you or someone related to the business. Basically, it has to be served that way. Sometimes our investigators do that in person. They'll actually show up at your business address or your home and serve it that way. Sometimes we send it via certified mail. So, usually if one's going to be served, we'll get it served in some way. But the way the process works is that for the first, basically once the CPAN has been served, that's the trigger date for the subsequent steps. So once it's served, within 10 days, calendar days after that occurs, the served party, so the respondent in this case, so in this case a towing carrier, would have 10 days to pay 50% of the overall fine amount. So if the fine amount total is $2,000, say, within the first 10 days, you could admit liability for the cited violations and pay that 50% amount, so that $1,000 in the 2000 scenario. And that essentially what that does is that resolves the matter. So it'll still go before the commission and they still have to approve it, but in pretty much all cases, they're going to accept that payment and then resolve the proceeding. So that's essentially the end of that process. Again, if you submit payments, that's essentially an admission of liability that the violations occurred. So just be aware that that's what you're doing when you make that payment. In addition, mailed payments, depending on the situation, sometimes we suggest that you actually just come and drop off a check at our office sometimes, just because things do sometimes get lost in the mail. And that's been frustrating a little bit over the years for the carriers when they submit payments and it never gets to us. That's, it's not good for anybody. So sometimes, if it's a situation you're worried about, sometimes it's easier to just come and drop off a check and make sure it gets to us. We do consider the mailed date, so like the postmark date, to be the date of the payment for such scenarios like that. But again, if we have a situation where somebody drops a check in the mail, on the 5th of the month, and we don't get it until the 25th, there's a lot of stuff going on process-wise in the background that can get a little complicated. So while we're waiting for that payment. So sometimes it's a good idea to just let us know that you dropped something in the mail too. You can always give us a call and let us know you submitted the payment, just so we know it's coming. That's possible, or you can reach out to the investigator who issued it and let them know. That's that as well. After that 10-day period, the CPAN essentially converts into what we call a notice to appear. So it basically, if that payment isn't submitted within the first 10 days, we essentially have it be converted to a notice to appear, which is essentially saying, okay, you're not intending to pay, so we're just going to keep moving through the process with that assumption. So that typically involves the commissioners hearing the matter during one of their weekly commissioner meetings. In pretty much all the circumstances, it's going to be referred to one of our ALJs or administrative law judges to adjudicate. So basically, it'll get referred to an ALJ. They'll be assigned, and then they issue interim decisions indicating what the next steps are. It will indicate hearing dates or deadlines to submit certain documentation, like witnesses, exhibits, and things to be presented during the evidentiary hearing. So if you're ever involved in that process, you should be linked into that because we serve the respondent as a party in the case, and so they should be privy to all the documents and filings that are happening in the background. That all culminates to what we call the evidentiary hearing, and that's where the ALJ will call the matter for hearing. Both the respondent and the complainant, and in this case, the complainant is the PUC and our accompanying attorney generals who represent us, essentially putting on the case and basically saying this is why we cited them. We'll provide all our evidence, verbal testimony, different exhibits to be admitted and presented and considered by the ALJ. And then it flips over to the respondent where they can make their arguments as well. So at that point, the ALJ will take everything under consideration. And then that moves on to the final step, which is the issuing of a recommended decision. So typically the ALJ will issue a recommended decision sometime after the evidentiary hearing, which outlines all the evidence and all the considerations, and then comes to a determination on whether or not the violations were proven to have occurred, and also what fine amounts are assessed. We always assess the maximum fine that's allowable under our different violations per statute or rule, but the ALJ has some latitude on if those are the fines that are actually assessed. So you can always go onto the Commission's website and navigate some of those CPAN decisions, just to kind of look at some of the recommended decisions and what they look like if you like. It's all public information. If you look up any G proceeding, so for example, and it's year and then that prefix. So it could be 23G, and then all the 23G proceedings will pop up, and those are all individually issued CPANs, which all have proceedings. Now, even if the CPAN doesn't go to hearing, even if it's resolved at that first stage, for example, by paying the 50%, it still has a proceeding. Once CPAN is served, it's always issued a proceeding. So even if it's satisfied at the very beginning of the process, that proceeding number is still out there. Same thing with the ones that go through the entire process. In regards to the exception or the recommended decision, parties can also file exceptions and even triple R's, which is our application for rehearing, re-argument, reconsideration. So they're essentially appeals to the recommended decision in both cases. So that's something that you should be aware of as part of the due process. So if the recommended decision comes out and you don't like it, you can always file exceptions. You can always file a triple R. That is available to you. Typically, it's a 20-day window after the recommended decision, unless otherwise specified. And then, of course, post-action. So, for example, the recommended could say, once this becomes a final commission decision, then whatever CPAN amount was assessed, maybe it was $1,000, maybe it was $10,000, is due maybe 30 days after it becomes a final commission decision. And then at that point, you're in the post-action phase, and that's something that you'll be required to do. With towing carriers, we do have mechanisms within the statute where we can essentially immediately revoke their permit if you fail to produce payment on a fully processed and adjudicated CPAN. So just be aware of that. And we can use it to also deny subsequent applications. So just be aware of that. All right, moving on to what I'm sure a lot of you are interested in, common violations and issues. So I'd say probably the four biggest rules, at least over the years that I've worked at the commission, having spent 7 years myself in the investigations team, I'd say probably the most common violations fall under four rules, which is Rule 6508, which is the authorization rule, Rule 6509, which is tow invoice, Rule 6511, which is fees and charges, and Rule 6512, which is release procedures. So in my opinion, those are the rules that tend to get cited the most. So obviously you want to read through all of the rules completely, but really focus in on those four rules because that's where we tend to see the most slips. So, making sure you understand what is in that rule, what it's asking you to do, what our expectation is of your compliance with that rule, can only help you. And of course, I always encourage everybody, all of our regulated carriers to be proactive with your regulation. If you're not sure about something, give us a call. We'll talk to you and help you out as best we can. So, it's a lot easier to spend, 20 minutes on the phone with somebody talking through, tow invoice requirements than, having to deal with multiple cases, which take days or weeks or even months in the future, that all have tow invoice violations as part of that investigation. So really encourage everybody to be proactive. So moving into Rule 6508. So this is the authorization rule. Now, I've specified exactly as part of the individual rules, so A, B, C, D, and E, which ones we've updated based on the recent legislation, and also which ones are brand new based on the recent legislation. So as you can see, most of the ones in 6508 have been either updated or are brand new coming. So for 6508A, that's tow agreements and contracts. So we've had to update that rule based on the recent legislation. And essentially what this rule does is it ensures that tow agreements between private properties and tow carriers meet all the standards in that rule. Now, I'm sure anybody who worked in Colorado prior to August of 2022 is familiar, at least if you've done non-consensual tows, is familiar with what those contracts are like and what the standards are, because again, it's all outlined in Rule 6508A on what needs to be contract. One of the new kind of slices to this, based on the recent legislation, is for residential PPIs specifically. Tow carriers can no longer act as the agent of the property owners for the purposes of authorization. Now, that doesn't mean you can't have a contract with that property. It just means they can't designate you, the towing carrier, as the authorizing agent. So you can't authorize the tows yourself for those residential PPIs. So just be aware of that difference based on that legislation. Under 6508B, really, authorization is, in my opinion, the most important part of a tow. Is how do you have the authority to perform that tow in the first place? That's, to me, the most important aspect of a tow, a non-consensual tow. So obviously, you have to have proper authorization prior to towing the vehicle. You have to make sure the right person is authorizing it. I mean, if you got called out to a location and some random person comes up and says, "Oh yeah, I live here," you got to vet some stuff and make sure it's not like a disgruntled neighbor or friend or something like that. I mean, just do a little bit of legwork to make sure it's the right person that's authorizing, especially for spot authorization. You just got to be very careful with that kind of stuff. 6508B3 is what I refer to as the supplemental authorization. So that's an authorization that's independent from the tow invoice. So that's a mechanism that I think is being seen to be used a little bit more of late based on the recent legislative changes than it was prior to that, because in a lot of cases the tow drivers were authorizing tows prior to that. But anyway, that's a mechanism you may want to look into that you may want to start using. 6508C, expired vehicle registration. We already had a rule about that under that rule for expired vehicle registrations, but the language, I think we were thinking about changing the language anyway, but the legislature went ahead and did that for us. So now it's just specific to residential PPIs with the exception of law enforcement tows. So basically, if you're towing a vehicle on the basis that it has expired plates, expired registration, for residential PPIs, you can't do that anymore unless it's at the request of law enforcement. That's the only exception. So just be aware of that for the residential PPI situations. Under 6508D, so this one's brand new. It's the new 24-hour notice rule that everybody talks about a lot lately, it seems. So again, this is another one that's specific to residential PPIs, the way they set up the statutes. So be aware of what the exceptions are and how to navigate unique situations. And we do get a lot of calls on this where people will call and say, "Hey, this is the situation. Do I have to provide 24-hour notice or not?" And we'll give you our opinion on if it's needed or not based on how you describe it. Now, we're assuming how you're describing it to us is actually what it is. So please give us accurate descriptions so we can provide the best possible guidance to you. But yeah, just be aware of those exceptions and how to navigate. The 6508D rule lays them out in I think is a little bit clearer than the statute does, but it's all the same stuff that's outlined in the statute. It's just it's a little more point, almost like a bullet point, so that sometimes can be a little easier to understand. And also something that's come up a lot over the last year plus is the mandatory windshield placement for the notices. Obviously, make a good faith effort. We'd have people say, "Well, what if there is no windshield? What if it's like an old beaten up, RV that doesn't have a windshield?" I mean, do your best and take pictures just so you can show that it's there. That's usually the best way to protect yourself. And if something comes across our desk and we, ask for some kind of evidence on the fact that the written notice was provided, it's best to just have that available to show us. And then that moves on to what we just talked about, photographs. 6508E, this one's new as well. Again, it is specific to residential PPIs. I think most towing carriers have been doing this for years anyway, but it's a little more regimented now. So what you need is essentially 4 photos of the vehicle condition before you hook it. So it's all 4 sides, so front, back, both sides. Make sure it's not like you're not standing like 50 feet away or so. I mean, make sure the cars or the vehicles are in the full view of the shot. And then the other, so that's one criteria is the vehicle condition, those 4 photos, and then also 1 photo for whatever the reason of the tow. So, for example, if the parking policy at that community is tow vehicles with flat tires, obviously that's not one of the exceptions for 24-hour notice. You're gonna have to give 24-hour notice. So taking a picture of the flat tire, there you go. There's your photo of the reason of the tow. And again, if it's also for something like a fire lane, which actually doesn't require 24-hour notice, that's one of the exceptions. Make sure you're taking a photo in relationship to a sign as best you can. So basically, if you have a vehicle that's parked in a clearly designated and marked fire zone, there's probably going to be a sign within shot of that. So taking a picture of the photo or a picture of the vehicle in front of the, red painted sidewalk. And if there's a sign there that says fire lane, no parking, all that, there you go. Just try to get it all in one shot. That really helps us out. So moving on to rule 6509. So 6509 is our tow invoice standards. And again, this is something that's unfortunately, it's really easy to get wrong. So just be very detail oriented. That's the best advice that we can give you is, just make sure you understand what the requirements are and make sure you hit every one of them for every towing. That's the best way to protect yourself. The other thing I've mentioned over the years to towing carriers is it's usually a good idea to create a tow template that kind of hits all of those points just so it's easy to see when a box is left blank. It's like, oh, well, if something's blank, we got to fill something in there. I kind of put an area of the tow invoice that is kind of slated for that particular piece of information. That way, when one of your drivers is looking at it and they see a blank spot, it's like, okay, what's the blank spot and what do I need to put in? And that's helpful in making sure they don't miss anything. However, I will second that by saying you could have the most perfect tow invoice template in the world, but really it boils down to who's filling it. So, you could have a perfect tow invoice, and if the person filling it out is not paying attention or, not all that interested, then you're going to start seeing gaps in the information, and that's a problem. So again, try your best to make sure, your tow drivers are aware of this stuff and, making sure that they're filling out all the different criteria to avoid these kinds of issues. So jumping right in here to 6509, the tow record invoice requirements. Again, just ensure that they have all the standards in the rule. Make sure everything's being written down, being included in the tow invoice, in the tow record. Also, the incorporated authorization versus supplemental authorization. I know we touched on that a little bit in the last slide. So again, for tow invoice incorporation, you splice that information pursuant to 6509A7, which basically says you need the name, address, phone number, and signature of the person authorizing the tow. That's really all the information you need for the proper authorization, as long as it's the right person, because all the other information is already on the tow invoice. So like vehicle information, the date and time, where the vehicle is being towed from, that's already included in other parts of the tow invoice. So really all you need is that information on the person authorizing it. The supplemental authorization, obviously you have more information, but that's because it's tracked separately from the tow. So you don't have that information that's already there to fall back on. So you have to write it down again on the supplement. So that's under, again, 6508B is that rule. Moving on to 6509B, which is the tow invoice for the consumer. So again, it has to include all the standards under 6509A, except for the tow driver name and signature. I think it's 6509A9, if I recall. That's something that changed probably within the last few years, which I know was a concern to some towing carriers, so we added that exception from the rule. And then records required to be kept for 3 years. So most PUC records need to be kept for 3 years. But yeah, this one, it's specifically spelled out right there in the rule that it's 3 years. Completing the tow invoice, 6509C, again, you're required to complete the tow invoice before leaving the property, unless impractical, like safety reasons or something like that. But even if that's the case, like you should be able to demonstrate why it wasn't done before you left the property. So again, in most cases, and obviously there's certain things you can't put down. So like, the total storage charges, it hasn't even hit the yard yet, so you're not going to be able to put that down. So, and we understand that, and we process them that way. But for the most part, I mean, if it's something you can fill out, you should be before you leave the property. Moving on to 6509D, providing the tow invoice to the consumer. Specifically for residential PPIs, and this was part of the new legislation, each charge needs to be kind of laid out by the charge and the rate for each of the towing fees. It's not as strict for the other types of tows, but for residential PPIs at least, you need to essentially put what the rate is that you're charging for. So like storage is this amount per day times however many days you're charging is the total. That's what it should look like. So just make sure you're doing that for all your charges. Or like cook fee is this rate times 1 because you only tow it once, I assume. And this is the total. So that's kind of how it should be itemized to fully comply with that standard. And then finally, under 6509E, the charge notification card. So that's specific to commercial PPIs because as part of the new legislation, you can't charge any kind of a drop fee for residential PPIs now anymore statewide. So just be aware of that. So, but for commercial PPIs, it's still allowed under 6511A. So, just make sure that you're using the form that's available on the PUC's website to do that if somebody comes at you for drop. All right, jumping into Rule 6511, which is rates and charges. There really wasn't too much that changed, at least in regards to like prices and stuff as part of this current rulemaking that we're going through. But we are updating some things, again, based largely on what the new statutes do. So under 6511A, which we just talked about, drop charges, if an authorized or interested person contacts you after the tow is initiated, but before the vehicle has actually left the property, that's considered a drop. So you can assess a charge for that for commercial PPIs, which is found, the rates are referenced and found in the tow rates and are referenced in 6511A. But again, because of that new legislation for residential PPIs, there's no fee for it. You can't charge. For 6511B, which is our private property impound, non-consensual tow charges, it's still, at least for the hook fee, which is really what's referenced here in this particular charge, it's the same still for residential or commercial PPI. It's still the same rate for both. It's just a PPI charge. But there's other parts of the fees that are a little bit different, and we'll get into that as we go down this list. But appropriate charges for a PPI include the hook fee, mileage and fuel surcharge, storage, after hours release, if applicable, and any other charges allowed by the commission or allowed by commission rule or statute. So certain things in statute, for example, that's not specifically outlined in commission rule, at least not yet, is the new credit card surcharge. So, those that's why we're updating those the way we are to accomplish for that. But at present, we're kind of letting the statutes control for those. For law enforcement order tows, the fee structure is a little different, as I'm sure some of you are aware. It's 6511C is what outlines the law enforcement order tows and recovery operation charges. It's an hourly rate as opposed to a flat rate, which is what you see for the PPI. It's essentially an hourly rate based on the GVWR of the towed vehicle. And it doesn't allow for some of the extra charges that are included in the PPI framework. So under 6511C3, for example, it says you cannot assess mileage or fuel surcharge. That's kind of rolled into that hourly rate. So really all you can charge is the hourly rate and not the mileage and fuel surcharge. Now you can still charge storage, and some of the other stuff, but yeah, just be aware that mileage and fuel surcharge for law enforcement or tows or recovery is 6511D. It has been for many years the accident reconstruction and stolen vehicle investigation rule. Part of the current rulemaking would be to eliminate that rule and just essentially default to the standard 6511C rates for law enforcement and recovery. That's not final, that's not official yet, because the rules aren't effective yet, but once they do become effective, then that rule will be. Moving on to what would be the new 6511D rule is storage. And this one's a little tricky, so I want to kind of try to explain it as simply as I can. For commercial PPIs and law enforcement ordered tows, it's basically the same structure as before, where you charge for the entire day of storage, like on the front end almost. So it's, for example, if you, as soon as you put the vehicle in storage, you charge for that first 24 hours worth of storage. And then as soon as that 24-hour period has lapsed, you can now charge the second full day of storage. And then when that 24 hours has lapsed, then you can charge the third day of storage. It's essentially what it was before the recent legislative change. For residential PPIs, however, it now has to be prorated on an hourly basis. So essentially how you get there is you take the max rate, so whatever max rate we have on the tow rates on our website, for the entire day based on the GVWR of the vehicle and whichever category you're in. And then you just divide that total amount by 24, and that'll give you your hourly. And so this is another reason why on the tow invoices, tracking, the date and time that it was placed in storage, the date and time it was released from storage, those are so important because our investigators do look at that and they make sure that the proper rates are being charged based on how long you actually have the vehicle. So be very careful with that and make sure you're not accidentally slipping an extra hour of storage. That could be a problem. So that's how that works for the residential PPIs. And then for all PPIs, so that's both residential and commercial PPIs, the way they made changes to Title 42, specifically 42.4.2103, which is the statutory notification standard statute. Really, you can only assess the first 24 hours on a prorated basis. So for commercial, even though, for the first, I mentioned earlier, charging kind of the full day on the front end, that works for commercial and law enforcement order tows, but only for the first, well, for commercial at least, only for the first or all the days after the first 24 hours, because that first 24 hours has to be prorated. So for commercial PPIs, you would use the same method as for the residential PPIs, but just for that first 24 hours. But then what I think some people haven't understood is that there's then no additional storage that can be assessed until the statutory notification process has been complete. Again, that was based on a change they made to Title 42. So basically, for example, say you tow a vehicle at 5 p.m. on a Thursday, and you can charge that first 24 hours on an hourly basis for that first 24 hours. So if they came and picked it up 2 hours later, then you could charge 2 hours worth of storage plus all your other fees and charges, and then release the vehicle. Okay. Say it was after 24 hours. So now you're 5 p.m. on Friday. So now you're 5 p.m. on Friday. Now you can't charge any additional storage until the statutory notification process is completed. So you run your IDS search, you get your names and addresses for your owners and your lien holders, and you send it out. Say you send it out by 7 p.m. I know the mail doesn't work that way, but say you send it out by 7 p.m. So at that point, 7 p.m. is now your new start of your next 24-hour period. So that's probably the best way I can explain it. So again, based on some updates we proposed to be made to the newest 6511D storage rule, hopefully lays that out in the same way that I just described it. But again, if you're still not completely sure about it, just give us a call and we'll talk to you and try to help you out. And then what would be the next the new 6511F rule, which is our non-compliance rule, is another big one. And I know I mentioned earlier, but yeah, if you commit any violations of either statute or rule as part of any tow action that you do, and we find those violations, you can't charge or retain any fees associated with that tow. So, if it's something you towed a week ago and, you know, whoever's vehicle it was filed a complaint with us and we found a handful of violations, again, the investigator will reach out to you and advise you, hey, I found XYZ, violations. And so, please, if you still have the vehicle, it's like, okay, you need to release it at no charge. Or if you already released it, during that week, then we would reach out to you and be like, okay, what was charged for that, and that you need to have that refunded. And then our investigators will usually work with you on that. They'll come pick up the check from you, or you'll mail it into us, and we'll get it back to the vehicle owner that way. But yeah, as you can see, considering we're talking about towing of vehicles, and especially with non-consensual and law enforcement order tows, we're talking about tows where the vehicle owner or operator had no say in the vehicle being towed. The standard is high, and we expect you to comply with all the standards in these rules and in the statutes. And if you do so, then no problem. But if you have slips here and there, that can lead to you having to refund a few tows. So again, it's always best to stay on top of this stuff and do everything the right way right out. Moving to 6512, which is the new release. It's the release standards under PUC rules. So we've updated some of these, as you can see, not too many of them, but because most of these didn't really get changed too much as part of the recent legislation. But under 6512A, which is our payment standard, essentially you're required to release to an authorized or interested person that's offering payment. Required forms of payment are mostly the same as they were before. It's cash and major credit card. And we consider major credit card to be Visa and MasterCard. So if somebody shows up and they got an American Express, I would still take it if I were you, but you're not required to per that standard. I think we also there's been conversation recently on debit card payments. I think we view that a lot just like cash because it's tied to the person's bank account. So I think that's something you should be accepting as well. Under 6512B, which is release standards. So that's your obligation to release vehicles during certain times or time windows. So basically, if it's regular business hours, which per our own rule we designate as 8 to 5 Monday through Friday, excluding holidays, weekends and holidays, it's upon demand. So if somebody shows up at your yard, there should be somebody there ready to release that vehicle. The other standard is if it's after hours, so sometime outside of business hours, then you have an hour's notice. Basically, you get an hour to facilitate that release. So if it's you tow a vehicle on Friday at 4 p.m. and somebody calls you at 11 p.m., as long as it's within the first 24 hours after the vehicle was towed, you're obligated to release it within it. So if you towed it at 4 and they call you at 11, you have till 12 to get there and release the vehicle. However, if you towed it at 4 p.m. on a Friday and they reach out to you at 7 p.m. on a Saturday, well, now you're outside of that first 24 hours window. You can still release it to them if you want, but you're not obligated to. You can tell them to delay that till Monday. But I would release it to them, especially if you're already doing business. In regards to 6512D, which is the release of personal property. So this is new. Some of it is new. We had some provisions in our rules from before that are pretty recent rules in regards to releasing personal property. But basically, personal property per the current and updated standards is any items that are not attached to or part of the equipment of the vehicle. So basically, if somebody showed up and said, hey, I want my personal property, but then they start trying to take the tires off, yeah, that doesn't work. That's part of the equipment. Or, same thing, something, maybe it's like a Jeep and they got a spare tire on the back that's like a nice tire. That, that's attached to the vehicle. That doesn't count. So, but it's basically everything inside the vehicle. So it could be papers, could be tools, could be clothes, could be, whatever. So that is all considered to be personal property. Now, the standard under the new statute is that you have to allow release of that personal property within 30 days of the statutory notification. As part of the new rules we've drafted, we're actually starting the clock on when you put the vehicle in storage. So if somebody, even if you hadn't done statutory notification yet, that's not like a loophole. It's, you still have to release it, when they come and ask for it. The way it works out from a price standpoint, because we did allow for fees before for that service. For a commercial PPI, you can assess the hook fee based on the GVWR for that tow. So basically, if they were in the 10,000 or less GVWR hook rate, you can charge that hook rate and allow them to go in and take whatever they want. For a residential PPI, however, no fee is allowed. So similar to the drop fee for residential, you can't charge. So you still have to allow them to, take their personal property, but you just can't charge for it. For a law enforcement ordered tow, that used to be looped into kind of the way we'll be doing commercial PPIs moving forward. But we instead tied it to whatever the maximum hourly rate is based on the GVWR for that law enforcement tow for that same thing. So, and that's not the overall hourly rate you've charged for that tow. It's whatever the rate is. So if you spent 2.5 hours on that tow, you can't charge that 2.5, like your full hourly rate charges for that, just whatever that singular hourly rate is. That's what the way we drew Jaffe rate. That's what it is. So just be aware of that. Under 6512E, release exemptions. Just be aware that there are some exemptions to regular release standards. There's only a few, like I think 5, but it's stuff like, if the person's clearly like intoxicated or on drugs or something like that, you can deny on that basis. If it's a law enforcement ordered tow and there's some additional release criteria as part of that written contract, that can be an exception. If you need a law enforcement officer present to facilitate the release because there may be an incident, that's an option as well. So there's not a lot of them, but there are a few there. So just be aware of what those are under the 6512. Under 6512F, and this is one I've talked about quite a bit, especially recently. It's what we call the authorized operator release standard. It's basically a mechanism where it identifies the specific minimum criteria to release a vehicle. So the standard is that you're releasing the vehicle to somebody who is demonstrating that they're a quote unquote authorized operator of a vehicle. So as opposed to the vehicle owner, for example, which, maybe somebody shows up and they produce a title of the vehicle that clearly has their name on it. You pair that with their ID, and it's like, okay, yeah, this is your vehicle. If you're comfortable with that, go ahead. You can go ahead and that way. But under this metric, it's basically where you're obligated. So what the standard requires is 3 different things. First of all, it requires the person coming and disclosing that they're the authorized operator. It requires them to present a valid driver's license. So it's a driver's license they're presenting to the towing carrier, and it has to be valid. It doesn't say Colorado driver's license, just says driver. The other is a signed attestation. It's a form that's available on the PUC's website. It's pretty simple. It's a kind of like an affidavit almost. And it basically outlines, I'm this person, the person collecting the vehicle says, I'm an authorized operator, the signatures and all that stuff. And then the third item is they have to provide 2 of 5 criteria. So basically there's a list of 5 things. And if the person shows up, has a valid driver's license, signs the attestation, and provides 2 of the 5 things, you have to release the vehicle. That's how that works. I mean, as long as they're providing payment. So, but this is how they demonstrate that they're an authorized operator. Like this is the official way that they can do it. If they provide you with, other documentation or other things where you're comfortable releasing it to them, that's fine too. But a lot of towing carriers use this mechanism. And again, the form's available on the website. It's fairly easy to navigate, I think. Moving on to 6512G through J, that's the release of what we refer to as protected items. So these are items that really, no matter what kind of tow it is, have to be released free of charge, immediately free of charge. Like that's just what the situation is. So it could be things like prescription medication, medical equipment and devices, child restraint systems, credit cards and cash, if said credit cards and cash are to be used immediately for payment to you, the towing carrier, state and federal identification, cell phones. These are the items that, and these have been on the rules for many years, are the protected items and always have to be released at no charge. Moving on to 6512L, this is the new, I've referred to it as the release without full payment provision. Different people call it different things. Some people call it the 15%, $60 rule. Some people call it, you know, reduced fee release. You know, people call it different. I call it release, that whole thing. So first off, you just want to be aware this is specific to residential PPIs. The framework for this was in the new 405 statute, and that is specific to residential PPIs. So just be aware of that. It does require the form on the PUC website to be filled out. So that is the form and the only form that can for this process. So it's called the Towed Vehicle Release Notice Retrieval with Payment Owed. Going back earlier to when we were on the website, it's the highlighted form on the list of forms that are available on the main towing website. So that's where you can easily find it. But yeah, it basically you fill that out completely, and you know that vehicle has to be released to that person with that less than full pay is how that works. All right, just briefly, Rule 6513, which is the notice rule. So this is in regards to, there's a lot that hits here in this rule for signage, so I wanted to touch on it really briefly. So notice and abandoned motor vehicles. So towing carriers can't non-consensually tow a vehicle other than an abandoned motor vehicle if it has not provided proper notice. Now, an abandoned motor vehicle, which is the exception of that first point, can be towed after 24 hours. Notice would still be required if it's a residential PPI, but if it's a commercial PPI, there's not really any notice required, but the towing carrier is still going to have to be able to in some way demonstrate that the vehicle had been there for 24 hours before it got towed. So just be aware of that. The proper notice that just historically towing carriers have used is signage, because that's really been the easiest way for them to properly demonstrate that notice has been provided, as long as that signage that does meet the PUC criteria. So moving on to 6513C on posting signage. So basically, you're required to post signage conspicuously at each point of entrance to the private property. So that means, you know, having it actually facing outwards so that people see it as they're pulling in. It has to have certain size and lettering and coloring requirements, you know, and all of that. So, but at each point of entrance, that's the key point under 6513C, because basically a good, you know, way to think of it is if you're at a particular private property, can you get to a space without seeing a sign? If you can, there's probably a problem. So that's a good kind of just basic litmus test that you can use. Is if I can get onto the private property and park somewhere without seeing a sign, then there's a problem. And again, I'm not talking about like somebody just didn't happen to see a sign. I'm talking you can't see a sign. Like even if you're looking for it, like that's when there's usually a problem. Make sure that your drivers going to various private properties to perform tows are doing scans and checking, making sure those signs are still there, because you know, sometimes they do get removed. So yeah, just keeping an eye out, and you know, having a spare sign in your back truck isn't a bad idea to just reaffix it from where it was if it gets taken down. So moving on to 6513D, which is the signage criteria. Towing carrier signage is required when a contract is in place with the private property. And I don't know why a towing carrier would put signage if they didn't have that contract in place. But anyway, that's when it's definitely required. Again, there are criteria on the size of the sign, the lettering on the side, like the size of the lettering on the side or on the sign, the color of the lettering on the side, you know, making sure it's not like black on dark blue lettering, like nobody can see that. So, you know, just stuff like that. There's also some language requirements on there, like, you know, having the tow carrier's name and phone number and that kind of stuff. So yeah, just make sure that all that stuff is on. There's also positioning requirements. Again, it does have to face outward at the entrances. And we have had that issue before where it's on the sign but it's faced in, so nobody sees it coming in. They don't see it going out. That doesn't help. Like people have to see it coming in. It also has to be visible and unobstructed. Don't put it behind a bush or anything like that. Make sure people can see it. And it has to be at or around eye level. There's specific height requirements, but I mean basically it's around eye level. It needs to be there. And then last point, which I know came up in the recent rulemaking, is the authorized parking only. That is the phrasing that's in the statute in quotes. So that has to be signage. So anyway, just be aware. And if you have signage already posted that doesn't say that, maybe you can, print out a nice weatherproof sticker or something and slap it on the sign somewhere so that it's there, because that is the new required. Just some other things on VIN check and notification, just because this does come up a lot with our investigations team. Again, these are the respective statutes based on where you're towing the vehicle from, so the origination point. If it's a public property tow, you'll want to look at 42.4.1804. That statute didn't change as part of the legislation last year, so it's still the same as it was for many years prior to that. The whole 2 to 10 days, to do the search and all of that. That's none of that changed. You can still charge 150 for it. Again, they didn't touch 1804. It's only 2103 got changed. So that's the other statute, 42.4.2103. Again, for the VIN check, so that's the IDS search. You have to do it within 2 to 10 days for public and within 10 days for private. That's the change. Obviously, you do that initial IDS search first for local records in Colorado. My understanding of the process is when you run the IDS search and there's no hit, there's an automatic trigger for the national search, which then DOR responds to that and lets you know if there's anything through their national search. The PUC's position is, and has been for a long time, is that you need to do both the VIN check and the notification in order to charge the fee. It's all part of one process, and either you've completed the process or you haven't. So if you've done the IDS search, but then somebody picks it up before you have a chance to send the letters out, don't put that charge on. Again, because the process has not been fully completed. The charge again is the same as it was before for public, which is 150, but they cut it in half for private, so now it's 75 for the private notification. So just be aware of that distinction. Notification has to happen 5 days after you get the records, so make sure you're being pretty on the ball on that. Don't lapse that deadline. And please contact all vehicle owners and lien holders. So if there's two people listed as vehicle owners and one lien holder, contact all three of those. Also, if there's one owner, for example, and they have 2 addresses, please send it to both addresses. Obviously there's going to be some different overlays to the situation if there's a law enforcement or a district attorney or other government hold on the vehicle, because obviously there are certain things you can't do, like release the vehicle, for example, when that hold is in place. But that does not absolve the requirement for statutory notification. You still have to comply with the standards in statutory notification statutes. You still have to do it. You still have to meet all the time windows and still do it. Now, we've had that argument, well, why are you alerting me that my tow or that my vehicle is towed if I can't come get it? Because that's what the statute requires. So please do that, even if there's law enforcement or DA hold in place. Just a few other items before we wrap up. Keep your contact info updated with PUC. Again, a lot of our official business mail and alerts and things like that, it does go out to whatever information we have on record for you. It's usually based largely on whatever was on your most recent application. We update your information, whether it's an address or a storage facility address or an email or a phone number. We update it based on what's on your most recent application. So make sure you have any and all addresses, storage facility addresses, phone numbers, and email addresses on every application and renewal application that you submit, because we will take ones off if you don't put it on everything. So please just make sure any and all contact information you want us to use, please put it on. Also, tow license plates, that's 42.3.235.5. Make sure that if you're operating a tow truck, that it has the proper plating. Get with Department of Revenue, DMV for that. So they're linked into our records, so they should be able to see through their drive system, which we feed our information into, that you have a proper permit and can issue that plate. If you have any issues, just give us a call and we can talk to the clerk. Secure vehicle prior to leaving. I know we talked about that before. You should be filling out the tow invoice completely, but also securing the vehicle completely prior to leaving. Throwing half a strap on there and then pulling 2 blocks down and finishing doesn't work. You gotta secure completely before you. So please do that. Additional charges, again, if it's not in our rules somewhere, please don't do it. We've had instances in the past where towing carriers will assess like a law enforcement fee as part of their fees to the customer. Please don't do that. That causes all sorts of problems. So again, if you're not sure about something, call us and we can talk about it. But yeah, putting charges that are kind of outside of the scope of what we outline in our rules and on our tow rates that are available on our website, if it's not there, you probably shouldn't do it. Insurance info to the consumer, that actually is required by rule. We consider our insurance forms to be public information anyway per rule here at the PUC. And so we release it to them anyway. So if somebody asks you for insurance info, go ahead and give it to them because one, it's required by rule for you to do it anyway. And two, if they call us, we're just going to give it to them. So please make sure if people are asking for that you provide it. And then releases and refunds. Again, when we request that, just give that its due attention. Please respond timely. If you have questions or whatever, you can reach out to the investigator who sent it to you. But again, we don't ask for that unless we have substantial evidence supporting that violations occurred. So it's, we're making legitimate requests when send those out. All right, to wrap up, I just have some contact information for you here. We have our main number, 303-894-2000. That's just our main PUC line. If you want to get to transportation, I think it's option 4 that gets you there. Consumer affairs and complaints, I know we talked about them a little bit earlier. That's the hotline I mentioned earlier, 303-894-2070. So, I mean, and again, we do get complaints from carriers sometimes. It's, if there's carriers out there that are following the rules and they see other carriers that are not following the rules, they tend to let us know because, again, everybody should be following the same rules. So, we encourage you all to let us know what you're seeing. We can't have boots or eyes on the ground everywhere. And so you letting us know and keeping your ear to the ground on things that are going on in the industry can really help us out if you let us know what's going on. So we really appreciate those when you get filed. Myself, Nate Riley. Oh, I just noticed I forgot to introduce myself when we started. Sorry about that. So Nate Riley, I'm the section chief here for transportation. I've worked at the commission since about 2012. Worked in investigations for 7 years, been section chief for almost another 3. So anyway, that's my number there, 303-894-2848. Lloyd Swint is the head of our investigations team. His number is there, 303-894-2263. Our address is here in downtown Denver. That's actually where I am right now, 1560 Broadway, Suite 250 in Denver. So usually if you're going to come by, we recommend you call ahead and talk to somebody here just so we know you're coming, so we can kind of make sure somebody's here to accommodate you. And then emails, I put mine and Lloyd's both on there. It's just our respective names at state.co.us. So Nate.Riley and Lloyd.Swint at state.co.us. So feel free to reach out anytime. You can give us a call. You can send us an email. We try to respond pretty quickly to this kind of stuff. So yeah, please, like I said earlier, we really encourage everybody to be proactive with their regulations. So if you're not sure about something, or something's confusing, or you encountered a unique scenario, that's one thing I've learned over the years about towing carriers. They have the most unique scenarios comparative to what our rules actually say than any other industry that I've dealt with. So we understand, you have complex and convoluted situations come up, and again, if you give us a call or send us an email, we'll try to help you navigate those as best we can. But yeah, I just encourage everybody to be proactive, read the rules, be involved, come to events just like this and participate. It all really does make a difference. So definitely applaud everybody that's here and everybody who's watching this on recording later. Get this off. And we'll jump into our Q&A. So, hold on, I'm just seeing some. I had the comments up, but these were not popping up when we were going through our stuff. So sorry about that. So I'm just going to read the first comment, and then if anybody wants to just shout out loud any other conversation points, we can jump into that. So it says on law enforcement tow regarding storage, does storage start as soon as the vehicle is impounded, or do we have to wait until the vehicle is there for 24 hours? For example, if the vehicle is brought in at 2 a.m. and is picked up at 11 a.m. the same day, can we charge that day of storage? So you can charge yes. So for law enforcement order tows, yes, you can do that. Because again, the restrictions based on the new statute language that was put in last year was under Title 42, 42103, which is the private property statute. So again, if we're talking about a public property tow, which is where the vast majority of law enforcement order tows originate from, then that they didn't really change that. And so basically for a law enforcement order tow, I don't think you ever have to prorate it. Hold on. I have a copy of the rules right here. Let me just double check that. So it's going to be under, again, our new 6511D rule. So for law enforcement, hold on, check it. Yeah, so this will be under what would be new if they get adopted and go into effect. It'll be 6511D1D, and it says for a commercial PPI or law enforcement ordered tow, storage charges may be assessed for each 24-hour period or any portion of a 24-hour period. And it says the 24-hour period commences when the vehicle enters the storage carrier's storage facility. For example purposes, it says the second day of storage for purposes of charges shall not begin until 24 hours after the motor vehicle entered the towing carrier storage facility. So really that's like the standard for most storage days. However, for commercial PPI, because it's a PPI, has that extra overlay where the first 24 hours of storage has to be prorated. Then it switches to the same standard as law enforcement order does from the get-go. So I hope that answers your question. Let's see, but if they picked up within a few hours, do we then charge the hourly rate on law enforcement? No, you can charge the whole day. So yeah, no, and again, I know I may not have described it the right way earlier, but yeah, so essentially you have 3 different ways that you need to assess storage correctly based on what type of tow it is. So you have, obviously consensual isn't involved because we don't regulate those rates, but you essentially have law enforcement and PPI. However, PPI is then further split into 2 categories, which is residential and commercial PPI. So for law enforcement ordered, it's essentially the same as it was before, where you can charge the entire day's worth of storage as soon as that vehicle hits the storage yards, but then you can't charge any additional storage until that full 24 hours is run. But then as soon as you're at 24 hours 01, now you can assess day 2. And then when you're at 4801, day 3. That's how that works on law enforcement. So yeah, I understand. It's a lot more convoluted than it used to be. We used to kind of have a just uniform across the board standard. Unfortunately, we just can't do it anymore that way because of the way the new statutes are implemented. So anyway, so yeah, so for law enforcement, it's the same way as it was before, no real changes. For commercial PPI, it's mostly the same as it was before, with one subtle change, which is for the first, well, 2 subtle changes actually, which is for a commercial PPI, you can charge the first 24 hours prorated, and then cannot charge. So that's the first part. Then you cannot charge any additional storage until statutory notification has been completed. Once you do both of those things, or basically if you've done both of those things, then you can essentially start the clock again once statutory notification has been completed. Then you start the clock again, and it's like you put the vehicle in at that time. And now you can run on the 24-hour clock, charging on the front end, just like law enforcement. But you have to make it first that statutory you have to make it past that statutory notification stage first before you can do that. And then for residential, it's similar to the commercial with one difference on the back end, which is it's the same as commercial in that you can only charge the first 24 hours prorated. Then you can't charge any more storage until statutory notification is completed. And then once it's completed, you can start charging storage again, but you continue to charge on a prorated basis for residential PPI. So those are the key distinctions between all 3. We may try to come up with a chart or something that explains this a little better, because there's a lot of people getting confused by this. And it's while it makes pretty decent sense in my head, I'm also totally, just ensconced in this information. So of course it makes sense to me. But yeah, no, we may consider putting together some kind of a chart or a graph or a visual aid to help with this, because I can see a lot of people getting confused by this, even with the way we tried to simplify it in the new rules anyway. Okay, let's see, moving along in the comments. Is there a cap on storage for a law enforcement tow on hold? I don't think there is, because if you actually look at the statutory language, hold on, let me pull it up here real quick. There is for a private property tow, but for a public property tow, I don't know if there's a cap. It's 120. It's 120 days for a private property tow. However, if there's a hold in place, I believe we allow you to extend those charges until the hold is released. So, for example, if you towed a vehicle, again, private property tow, so you tow a private property, and you've had it in storage for 90 days, and then somebody shows up and picks it up, or it gets sold, whatever. At that point, you can charge 90 days and nothing more than that. But say there was a hold, and after 90 days it got released, and it was either picked up or it was auctioned sometime shortly after that. You can continue to accrue storage past the 90 days up to the 120 cap. However, if it was on hold for 150 days, for example, I believe our stance on that is you can continue to charge that daily storage rate up to the 150 days. But then if that's the day on day 150 is when the hold gets released, then that's when you have to stop storage. Even if you continue to hold it past that date, you can't charge for it after that 150 because you're already past the cap, if that makes sense. So that's how I describe it. But yeah, for law enforcement order tows, let me look real quick here at 42.4.1804. I thought there was something in there about, oh, no, sorry, 1805. Because I thought there was something about some trigger from law enforcement. Yeah, take a look at 42.4.1805 because the 120-day cap on the private property side is in 42.4.2104, which is one statute after the statutory notification statute. So I did the same move on 42.4.1804, so that would bump it up to 1805 for the appraisal. And I think there's, oh, wait, here. So 42.4.1805 1B, it says subject to section 42.4.1804, the operator may continue to charge for daily storage fees until the responsible law enforcement agency complies with this section. So there is some kind of a trigger in there. I don't know if that translates to a max. You may want to reach out to DOR and see what their thoughts are on that. All right, I think we've made it all the way through the written comments that got put in. Does anybody? Oh, sorry, we got one new one. What are the procedures for when there is a complaint filed against us on law enforcement order tow, but the investigator sends us questions regarding a residential PPI on that same call without having to go to court to clear up? There seems to be a lot of confusion determining if it is a PPI residential, PPI commercial, or law enforcement order tow. I guess I don't see the distinction between those tow categories as very overlapping in a lot of cases. I mean, there's exceptions and outliers to that, of course, but I think in general, we can look at pretty much any tow that comes across our desk, and we're going to easily know if it's a PPI residential, PPI commercial, or law enforcement order. It's usually pretty easy to tell. So law enforcement order, again, usually has law enforcement paperwork that goes along with it. It typically originates on public property because law enforcement are the only ones that can actually authorize tows from public property per statute. And then with residential PPI versus commercial PPI, in most cases, and our investigators are very thorough, and they run, how different properties are zoned and all of that to check this stuff. But usually it's pretty easy to tell at first glance whether it's a commercial or residential PPI. I mean, it's like, oh, this one came from a condo, that's residential, or oh, this one came from Home Depot, that's commercial. Like in a lot of cases, it's that simple. Now there are some multi-use and multi-zoned properties that we've seen, but there's not. I don't know that we've seen a lot of those. So there are some outliers to this kind of blanket perception, but I think in most cases, we can just look at the tow, what the origination point is, and a couple other factors, and we can easily tell which category it goes into. But back to your original question, what's the procedures when there's a complaint filed against us on a law enforcement order tow, but the investigator sends us questions about a residential PPI on that? You say on the same call, like you towed a law enforcement order tow, and then you coupled that with a residential PPI. I guess I don't fully understand that first part of the question. Feel free, anybody, to jump off mic and jump in if you don't want to type it out. Oh, okay. So you're talking about when it maybe starts out kind of like a law enforcement order tow, but then potentially converts to, when you say private, I assume you meant consensual. And we do hear about that quite a bit, yes. But hold on. Sorry, Michelle. It was a law enforcement order tow, but I received PPI questions that did not pertain. Well, and so if they don't pertain, they don't pertain. Um, because and I mean, feel free to use that those clarifications in your response. Car a car in a tree on private property. Wow, that's interesting. Could not answer the question sent to me. It was a car in a tree on private property. Okay, so yes, there are going to be instances, and again, this is kind of one of those outlier situations where it's a law enforcement order tow that actually originates from private property. That puts kind of a weird spin on a lot of our criteria, just because, again, with this new residential versus law enforcement order tow split, I think we defer to law enforcement in those situations. So basically, if it's a law enforcement order tow that just happens to be originating from private property, which I think we can all agree is not the majority of the time, or even a decent amount of the time. I think those are pretty rare instances. Um, then we're going to treat that as a law enforcement order tow. Yeah, it may have originated from residential, but again, it's a law enforcement order tow, so that I think supersedes the fact that it just happened to come from residential property. So I still think in that particular situation, it still seems like you could still assess the law enforcement order tow rates because again, they're the ones who are telling you to tow the vehicle. It's a law enforcement directive. So that seems pretty clear that that's a law enforcement order tow. So then all of our rules that we have in place, you'd want to look at, yeah, law enforcement, the fact that it's a law enforcement order tow and adhere to all those specific requirements. Now, it could end up being a little tricky when it comes to statutory notification, just because it was a private property tow, technically, as opposed to a public property tow, which obviously, if it was towed from private property, it's not a public property tow. But it doesn't really quite engage law enforcement at the same extent. That's a good question. You might want to check with whoever you're contracted with in law enforcement for those types of tows and see if they have any guidance for you on how you should be adhering to, some of these standards. Because again, to me, it doesn't make a lot of sense that you do follow the standards outlined in the public property 42.4.1804 statute for a tow that actually did originate from private property. That doesn't make sense to me. But on the private property statute under 42.4.2103, there's not really a lot of reference to law enforcement there. So it kind of is a weird situation to try to apply those standards to. So you might want to. It's a good conversation though. I think we could, if you want to call us and we could talk more about that. That's a good road we could go down to kind of sort some of those issues out. But yeah, it's a car in a tree. Yeah, I could see law enforcement being involved in that. All right. Let's see. Okay, I think those are all the chat comments. So if anybody wants to jump in, off mic and we can just talk, that's fine too. It's about 2:40, so we still got about 20 minutes left in our time frame. So I'm happy to stay here for the whole 20 minutes and chat more about whatever you like. But yeah, I know we went through a lot of info today, so if all of you are burned out, I understand that too. But yeah, Rochelle.
I have another question. So on release procedures and requirements, you didn't touch on current registration and insurance. Can we require them to have that, or is that not a requirement that we can have?
So wait, you said current registration and insurance?
Yeah, so you had touched on they have to have a valid driver license. They have to have, be an authorized user. They have to meet the criteria. Can we also require both registered owners and authorized users to have current insurance and registration if they're driving the vehicle off of our property?
So technically not, because, well, hold on, let me look at E real quick. I'm looking at 6512E just to see if there's something in there we can use for this. Because yeah, under E1, so under E, that's where the exceptions are to our release standards, is under 6512E. And it says the towing carrier at its discretion need not comply with paragraph 6512A through D to release a motor vehicle or allow for removal of personal property if And then the first one is towing care. Here, let me share this just so everybody can look at it. And I'm looking at the red line version from the current NOPR because there's some changes that may be coming. But yeah, it's the first one is the towing carrier is reasonably certain that at the time the motor vehicle is to be released, the driver of the motor vehicle is not capable of safely driving the motor vehicle due to influence of drugs or alcohol. Another one is towing carrier that is to remove the motor vehicle from storage does not have a valid towing permit from PUC. A hold order is in place by a court, district attorney, law enforcement, or law enforcement officer. The release of the motor vehicle does not complete with the release procedures agreed to in writing between the towing carrier and the applicable law enforcement agency. We talked about that earlier. If there's additional criteria in a law enforcement contract, that can be grounds to refuse release. And then the last one is the towing carrier, upon notification for release of or access to the motor vehicle at other than the carrier's business hours, so after hours, has immediately contacted an appropriate law enforcement agency and in the interest of public order, has requested the law enforcement officer's presence during the release of the motor vehicle. So really, I'm not seeing anything in there about not having a valid license or insurance. But at the same time, I understand that concern with letting somebody who's not licensed or properly insured, driving off and doing who knows what. I get that concern 100%. I don't know if that alone. So if you, I don't think there's anything wrong with asking for this stuff. And if they're willing to provide it, great. And they get it and you're comfortable and you release, no problem. But if you're denying release because they don't want to give that to you or they don't have it, that's, I think we're running into an issue because really, if they meet the criteria that's outlined in our rule for release, either they meet the criteria or they don't. And so if they don't, then you're well within your rights to deny access. But if they do, even though there may be some of these residual concerns, I don't know that alone is grounds to refuse release. However, if I've also heard arguments over the years where, for whatever reason, a towing carrier for liability or insurance purposes did not want individuals coming onto their lot to get in vehicles and drive away. Like, oh, what if they, hit another vehicle on their way out? Then I'm responsible. Like, these are the arguments we've been hearing. And while we understand that, we don't think just that concern in and of itself is grounds to deny release if they've met all the other criteria that's actually outlined in the rules. So what we've advised over the years, and this goes back probably 5, 6, 7 years, that we've been advising towing carriers to handle it this way, these types of situations this way, is if one of those concerns exists, but they've met all the other criteria for the release, one of the things we've advised, especially in these situations where they just didn't want people coming on their lots, is to basically say, okay, essentially you're generating the concern and that's fine. And, you're in no way obligated to require them to come onto your property. However, you can't disrupt the release. And so your obligation now that you've essentially created for yourself is to hook the vehicle, drag it off of your property and release it there. So, and you can't charge for that. So, because essentially it's, you're essentially weighing your concerns regarding liability with stunting the outlined and sanctioned release procedures. So that's essential. That would probably be my guidance in this situation is if you're really, because at that point, if they're off of your property, I would imagine if they still decide to get in, even though they're unlicensed and uninsured, you released it, in accordance with procedures, and whatever they elect to do after that is kind of their business, is kind of the way I see it. But these are things I think we can continue to explore, as future towing rulemakings come up, because I definitely get where you're coming from on this, and I even get some of the other arguments I've heard from towing carriers on why they didn't want to release for XYZ reason. And a lot of those reasons are valid, but at the same time, unless it's specifically outlined in the rules somewhere, or it can apply to one of our exemptions, there's not really much latitude that we have at the commission to tell you can do something if it conflicts with the rule, like what the rule actually is, what the language is. So that would be my response.
All right. Yeah, thank you. So if the law enforcement that we tow for requires it, then we can require it. But
as long as it's in writing in the contract, absolutely.
Okay. All right. Thank you so much.
Thank you. So yeah, that's pretty clear in 6512E4, which says, the release of the motor vehicle does not comply with the release procedures agreed to in writing between the towing carrier and the applicable law enforcement agency. So, for example, as you described, if you have a contract with a law enforcement agency and you just performed a law enforcement order tow, and in that written agreement with law enforcement, it says, you, the towing carrier, the vendor, you are not to release a vehicle unless the person being, you're releasing the vehicle to has a valid driver's license and valid insurance. Now that is additional sanctioned release criteria for that particular tow. Correct. Okay. So moving on to our next question from Sarah. Thank you. Question on potential exceptions for immediate tows residential PPIs. Okay. With the snow in forecast, we've had properties reach out to have vehicles removed from snow pile areas. Typically, the trigger amounts are 2 to 4 inches. Would there be an exception on days like today where a vehicle is parked in those areas could be towed immediately? We've also had similar situations with vehicles blocking dumpsters on trash pickup day. So the only thing I can think of, and again, this is outlined in the exceptions to the 24-hour notice standard under 4010.14053B is where those are listed. But they're also going to be listed here in new rule. I think it's 6508. Hold on, let me find it. 6508. D as in David. So that's where we're outlining our new 24-hour notice criteria. So the only thing I can think of for that particular situation, I think I've had that question before from someone else up in the mountains somewhere. But the only thing I can think of where you might be able to justify that is under what would be the new 6508D1B as in boy. Which states that you do not have to provide 24 hours notice if the motor vehicle blocks a driveway or roadway enough to effectively obstruct a person's access to a driveway or roadway. So if somehow you can apply that lens to that particular situation, that might work. But again, it's going to have to either it fits that situation or it doesn't. If it's like if somebody's parked in a parking space that just happens to be in the snow day overflow, where they pile all the snow or whatever, then I don't know that you could I don't know if you could just move it on that basis alone. I'm trying to think if any of the other, because I assume we're talking about residential here. So it's residential. Okay. So let me think I'm looking at some of the other exemptions to see if anything else might apply. Because really what the exemptions are is if somebody's parking in a way that isn't one of the exemptions and you've been providing 24-hour notices, like you've provided at least 2 previous notices for some kind of inappropriate parking, like parking across 2 spaces or, whatever it is. So it's something that you can't tow immediately already. If you've warned them twice for a particular kind of parking behavior in the past 6 months is a layer we added as part of the rulemaking. But then on the 3rd time, you don't have to warn them again. You can just tow them immediately. So that's one exemption. Then you have the blocked driveway or roadway enough to effectively obstruct a person's access to the driveway or roadway. Basically parking in violation of, handicap spaces. So the reserved parking for people with disabilities, if you're parking there and you don't have the right placard or plate, that's one you can tow for immediately. Parked in or effectively obstructing a designated or marked fire zone, which I know I talked about earlier. The motor vehicle is occupying without permission or effectively obstructing access to or from an individually designated, rented, or purchased parking space of a resident. So basically, if you go to a parking lot and they have like individual rented or leased spaces, or maybe even deeded spaces at like a condominium or something, that's an immediate tow as well as motor vehicles parked without displaying valid authorization in a parking lot marked for exclusive use of residents. So like there's a lot or a portion of a lot that says parking permit only, and they don't have a parking permit. That's essentially what that means. So unless you can fit it into one of those boxes, no, you still have to give 24 hours notice. So, I mean, obviously you could maybe you and the property could kind of think ahead and be like, oh, there's supposed to be a big snowstorm tomorrow. Let's make sure and get some, notices on these vehicles that we're going to tow them because they're in whatever particular zone. It really either one of the exceptions applies or it doesn't. Now, some of them have a little bit of flexibility, but not a lot. So just understand that and read through those. And if you can apply one of them, then okay. But if you can't, then I wouldn't risk towing it early just to accommodate for that. In the future, we're also planning to address in rule something about situations where there's going to be like a power washing or a resurfacing of a particular lot in a residential area, where we could maybe create some kind of a scenario where vehicles could be moved from one part of the property to another part of the property. So we're trying to figure out a way that might be able to work, where it's not conflicting with anything, because we know that's another scenario that comes up from time to time. So, but yeah, that's probably the best answer I have for you for now. And that goes double for the blocking the dumpsters. Same thing. Again, if you can justify that them blocking the dumpsters is somebody blocking a driveway or roadway enough to obstruct access. I mean, if you think you can justify that, then okay. But again, it's in any tow you perform, you want to just imagine that tow invoice coming across our desk, and what are we going to think? That's how you have to look at it. So, because we get a lot of you never know who's going to file a complaint. You never know who's going to complain. So, you should always assume that every tow invoice you fill out, every tow you perform could end up on our desk someday. Maybe it's tomorrow, maybe it's in a week, maybe it's 2 years from now, but we may see it. And if we see an issue, we're going to address it. So just keep that in mind. Thank you, sir. All right. Any other chat questions? Anybody else want to jump off mic? We're kind of in our last 9-minute stretch here, but happy to keep talking till the end. And again, I just really do appreciate everybody being here. And for those of you who have participated in our previous ones as well. Again, we are going to be posting those up on our website on the towing webpage specifically. It'll probably be somewhere about halfway down the page where we currently have our TRPC training posted, which is a lot of the slideshow I went through today is on that one as well. Some differences, but anyway, so yeah, it'll all be there. This recording and the previous 2 ones as well will all be there. So if anybody you work with in the industry who didn't participate, but you think they might get some good info out of these, it's obviously a lot to listen through these 2-hour long training seminars, but there's good info here, I think, and it's good to kind of hear some of these what ifs and other situations to kind of see how the PUC might view it. All right. Anything else from anybody?
So I do have one more question.
Yeah.
So back to the law enforcement. Did you say that if we tow a law enforcement tow, that they require us to get, and if they have the proper information from the law enforcement, we have to release it we have to release it after hours with an hour notice? Is that what you said?
Oh, okay. So you're talking about the
after hours.
Yeah, the release standard under 6512. Hold on, let me scan that real quick. I think we are. It's a little unclear just with the rule. So what we had to do with a lot of our rules, because dating back to about 2015, I want to say, we essentially lumped non-consensual PPIs and law enforcement ordered tows into mostly the same category of we considered both of them to be non-consensual tows, because they pretty much are. But we had to change that based on the new legislation. They changed the statutory definition of a non-consensual tow to be a private property tow. And obviously we can't consider, just carte blanche law enforcement ordered tows to be non-consensual tows, because most of them do not, originate from private property. So we just couldn't justify that anymore. So we had to change our definition of what a non-consensual tow is. And so for a lot of our rules that prior to this current rulemaking really had only applied to non-consensual tows, we've had to add in law enforcement ordered tows, because otherwise we couldn't apply it to that kind of a tow. So I'm looking at 6512B as in boy, and that's what we're changing. That's what we're adding. So right now it says a towing carrier that accepts for storage a motor vehicle that has been towed as a non-consensual tow, which again, prior to the change in the statute, meant PPIs and law enforcement order tows. So now we've added the language, a towing carrier that accepts for storage a motor vehicle that has been towed as a non-consensual or law enforcement order tow shall provide access to and release the motor vehicle to an authorized or interested person of the motor vehicle, either And then that's when it goes into what we talked about earlier. So it's either upon demand during a carrier's business hours, or within 1 hour's notice during all times other than the carrier's business hours that occur within 24 hours of storage, which occurs within the first 24 hours of storage. So basically, it only applies in the first 24 hours. So if you towed a law enforcement order tow and it hit your yard at 5 p.m. on a Friday, and they call you up at 10 p.m. that next day, Saturday, you're outside of the first 24 hours. So you can refuse to release until Monday if you want. That's kind of how that rule works. I mean, you can of course continue to release at your discretion. It's just you don't have to. So yeah, law enforcement order, and you can still charge the after hours fee for it. That's fine. But yeah, really the only exception to that, and specifically for law enforcement order tows, is again if there's additional criteria for release, that if the law enforcement contract you have with that agency says the towing carrier only has to release 8 to 5 Monday through Friday. If that's the case, then I would consider that to be an additional release criteria, which is covered by 6512E4. That's the only exception I can think of.
Okay, thank you. I appreciate that.
So, all right. Well, yeah, we're butting up against time here, 2:55. So last call for any questions. All right. Well, again, I just want to thank everybody for being here. I really appreciate people being proactive with their regulations. So just being here and being part of the conversation, asking questions, just seeing kind of how we navigate some of these regulatory issues, I think is just really helpful for both our side and yours. And it also helps to be on the same page with each other, because then we're telling the consumers the same thing, which is helpful as well, because sometimes they can get confused by it. Just because there's so many towing regulations, it's easy to lose your way. So, but anyway, definitely appreciate everybody being here today. So we'll go ahead and wrap up. Again, thank you all, and hope you have a good weekend. Take care.